Hi, everyone. My name is Brian Elliott, and I am the Outreach Coordinator with ALRP. I want to begin by thanking the HIV Legal Services Fund of the American Bar Association HIV/AIDS Impact Project. Their funding makes it possible for us to bring you this training today. So just our agenda, I just want to begin by introducing our speaker, Phyra McCandless. She'll be providing the training today on HIPAA and privacy. At the very end, we can have time for questions, and we'll be wrapping up at about 1:30. So quickly for some housekeeping, you should have received materials from me last night and this morning. If you did not get the materials that I sent out, you can send me a message in the chat and I will make sure to send them to you right away. We will reserve time at the end of the webinar for questions. ALRP is a certified MCLE provider in the state of California. So we are glad to provide you with 1.5 hours of general CLE credit to California attorneys joining us this afternoon. I hope that you'll be able to take the time to fill out our brief evaluation at the end of the training. It will appear in your browser when you exit Zoom, and will also be linked in a follow-up email tomorrow. Evaluations are required for those of you who are seeking CLE credit. I will email you your certificate once I receive an evaluation from you. We'll be recording this training and sharing it as a resource for anyone interested. It's going to be on CLE Hero. I can send you a link if you would like to watch this again. So here's some of our upcoming CLEs I just want to let you all know about. We have another episode of our privacy series with attorney James Wood, which is coming up on November 4th. He's going to be going over a review of settlement strategies and litigation procedures. And on December 8th, we're going to have another CLE. This is going to be for competency credit, and it's going to be put on by Gina Cho, and how mindfulness can improve your labor law practice. So before we get going, I just want to let you all know a little bit about ALRP and what we do. ALRP was founded in 1983 in response to the AIDS epidemic. At the time, ALRP was simply 4 attorneys who were drafting wills and durable powers of attorney for those who were dying of AIDS. Drafting legal documents such as these allowed individuals to die with dignity and fulfill their wishes about healthcare and disposition of their assets. As treatment has evolved, so has ALRP. Since 1983, ALRP has handled over 80,000 legal matters for our clients. We are somewhat unique in our provision of legal services in that we offer direct services in-house with our staff of 12 attorneys, in addition to operating as a lawyer referral panel, maintaining a very large and diverse community of volunteer lawyers. Our staff and panel of over 700 volunteer attorneys help our clients in a variety of legal areas, including immigration, housing, employment, credit, insurance, family law, confidentiality, and government benefits. So our goal in offering these trainings is twofold. We hope to increase the capacity of the attorneys of our panel and other organizations providing legal services to people with HIV and AIDS. Second, we hope to recruit new talent to join our panel and help us meet the legal needs of people living with HIV and AIDS in the San Francisco Bay Area. If you're a local attorney that is not yet on the panel, I would hope you would consider joining our ranks. So as an attorney on our panel, you'll be playing a key role in helping us provide low-cost legal counseling representation to our clients. We ask the panel attorneys accept at least 2 referrals a year and tailor the experience to your experience and availability. ALRP conducts a thorough intake in order to make an informed referral and then provides a warm handoff. Once the client has been referred to you, the case is yours. Just a few of the benefits of serving on our panel include free MCLE trainings, mentoring, malpractice insurance, and networking opportunities. If you're interested in joining our panel or have any questions, please reach out. Contact information is right here for you, and you can email me directly. I'll put my email in the chat. But without further ado, I would like to introduce our presenter for today, Phyra McCandless. Phyra actually began her career as a health and welfare employee benefits consultant right when HIPAA was getting implemented. Her undergraduate degree is in psychology, and she has a master's in public health from Johns Hopkins School of Public Health and a law degree from USF. During law school, Phyra was an ALRP law clerk. As an Equal Justice Works AmeriCorps Legal Fellow, coordinating law student pro bono projects, Phyra managed relationships with nonprofit organizations and placed students in projects that fit the needs of the organization and interests of law students. As a postdoctoral fellow with the Center for Tobacco Control Research and Education at the University of California, San Francisco, she researched, presented on, and wrote about tobacco control policy and health disparities. Her work has been published in the American Journal of Public Health, as well as other legal publications. Phyra has represented clients in housing, asbestos, tobacco, pharmaceutical, medical device, and securities litigation, as well as whistleblowers and False Claims Act causes. She served as an assistant regional counsel to the Department of Health and Human Services Office General Counsel, Region 9, where she represented CMS and Indian Health Services in a variety of matters, including reviewing record subpoenas for HIPAA compliance. Phyra worked for the UCSF's Office of Healthcare Compliance and Privacy, where she trained healthcare staff on federal and state privacy laws and regulations. Most recently, Phyra was on the staff at ALRP, and she's now at USF School of Law's Office of Career Services. So please join me in giving Phyra a warm virtual welcome.
Thanks, Brian. So that was a long introduction, I apologize. So let's get started. There's a lot to cover. So essentially what I'm presenting is HIPAA 101. So some of it may be what you've heard, you've heard on behalf of clients, but a lot of it based on my experience in training healthcare providers. I will also give that perspective. Just for our objectives today, we'll learn what HIPAA is, including high tech. We'll learn what HIPAA is not. We'll give some key terms and jargon, learn about compliance and complaints, and learn about enforcement. So what is HIPAA? You'll notice that the word privacy is not in HIPAA. It stands for the Health Insurance Portability and Accountability Act. And it is a federal law created to address the transmission of healthcare information, to establish how personal information is protected by healthcare providers from fraud, and to address the limitations on insurance coverage. And so what we'll mostly be talking about, and what we know about and what a lot of people hear about, is the privacy rule. And the HIPAA privacy rule created guidelines for covered entities concerning the use and disclosure of protected health information. The HIPAA security rule pertains to the use and disclosure of electronic PHI. And we'll get into what these key terms and jargon mean as we continue. HIPAA now includes what's known as high tech and the final omnibus rule. So high tech is the Health and Information Technology for Economic and Clinical Health Act. And it was part of the economic stimulus package that was introduced during the Obama administration under the American Recovery and Reinvestment Act. So it includes standards for electronic records and data sharing in clinical setting for quality reporting, other health population purposes. It also included standards for administrative, financial transactions, cost savings, and then additional standards for security and privacy to protect patient identifiable information. The goals of the HITECH Act were to promote and expand the adoption of health information technology, specifically the use of electronic health records, or EHRs, by healthcare providers. So the HITECH Act also removed loopholes that were in HIPAA to help ensure that business associates, which we'll get into a little bit more later, of HIPAA covered entities were complying with HIPAA's rules, and notifications were sent to the affected individuals when health information was compromised. It also included tougher penalties for HIPAA compliance failures and introduced an extra incentive for healthcare organizations and their business associates to comply with the HIPAA privacy and security rules. So under HITECH, compliance with the requirements became enforceable on November 30th, 2009. And they were incorporated into HIPAA in what's known as the final omnibus rule, which brought HIPAA and HITECH together. And the omnibus rule was published on January 25th, 2013, and had a compliance date of September 23rd, 2013. So these are all in effect now. So a little bit more about the omnibus rule. It substantially strengthens HIPAA enforcement. And then there's a link here, and it increased the monetary penalties. It incorporated and clarified HITECH's direct regulation of business associates and their subcontractors. It allowed for direct application of the HIPAA privacy rule business associate provisions. There's a direct application of the HIPAA security rule safeguard and document provisions. There's direct accountability now to the government when there are violations. And then there are also significant revisions to the breach notification rule that were a part of the final omnibus rule. So just a little bit of background that privacy is bigger than HIPAA. And this is covered elsewhere. This was covered in some of Jim Wood's presentations. And then there's some privacy rules that aren't necessarily related to health. So so I did just want to cover a few things that may you may hear about that don't fall under HIPAA, but privacy is still important. For example, the Family Educational Rights and Privacy Act, known as FERPA, protects student education records. There are some specific rules that apply to HHS, Health and Human Services. And then, of course, states have their own laws. So we won't be going over these specifically, but some of the privacy rules you think might be HIPAA are actually state, they're actually state rules. So they would be under the Confidentiality of Medical Information Act, or we call it CMIA. And then the Lanterman-Petrus Short protection of mental health records, more specifically, are some examples. But when does HIPAA apply? HIPAA usually applies to patient information from a hospital, medical files from a physician, an enrollee's information from a health plan, a nursing home residence records, or claims records from a healthcare billing company. And when HIPAA does not usually apply, it doesn't usually apply to OSHA records, that's occupational safety and health, life insurance, an individual client's personal medical data. For example, in medical malpractice plaintiffs or estate planning clients, HIPAA would not apply. It's not governed by HIPAA. I mentioned the education records under FERPA. That's a different law. De-identified health information and employment or personnel records. So there would be other privacy laws where these would apply, but HIPAA would not apply in these cases. So the initial title of this presentation was HIV and HIPAA, but HIPAA doesn't provide special protections for HIV diagnosis or status. It's another health diagnosis, so HIPAA is broader, but there isn't anything that's special to one's HIV status. Do be aware of HIPAA's requirements for obtaining health information from covered entities. There may be specific requirements for subpoenas. There are special requirements for authorization forms, and state privacy laws may apply. So a state such as California may have special protections for mental health and substance abuse and HIV status. And we'll go over that a little bit later. In some of the materials I sent, I gave some examples of forms that would be used where you may have to make an extra check mark to request HIV status or treatment information if that's needed. So onto the key terms and jargon. These are some of the examples. I've mentioned them briefly already. When we talk about OCR in this context, this is the Office for Civil Rights, that's what OCR stands for, of the US Department of Health and Human Services. And OCR at HHS is tasked with overseeing and enforcing HIPAA. Other agencies also have OCRs. They have their own Office for Civil Rights. But when we're talking about HIPAA and we reference OCR, we're talking about the OCR that's part of the US Department of Health and Human Services. The privacy rule is in the Code of Federal Regulations. It's at 45 CFR section 164.500. The final regulations were issued in December 2000 and August 2002. The security rule is under part 45 CFR section 164.300. And those final regulations were released in February 2003. And as I mentioned, that relates to the electronic records. And then the breach rule is codified in 45 CFR section 164.400. So that 45 CFR section 164 is your key guide to looking up the regulations. So I mentioned this quite a bit, the covered entity and what that means. And sometimes you'll see it, you'll see the acronym CE. A covered entity is usually a healthcare provider, a health plan, for example, insurance. So Kaiser would be a health plan or healthcare clearinghouse. Some examples, hospitals, nursing homes, surgery centers, physician offices, dentists, health insurance companies. Those are examples of covered entities. They are governed by HIPAA. Protected health information, or PHI, is any information to past, present, or future physical or mental health or condition of an individual. The protected health information, PHI, would include medical records, any information that identifies an individual as a patient or correspondence. And then we'll use the terms use, which is usually internal, how it's used internally at the covered entity, and disclosure, when it's disclosed, when it's provided externally outside of the covered entity. So business associate, or a BA, is a person who creates, receives, maintains, or transmits PHI on behalf of a covered entity or organized healthcare arrangement for a function or activity regulated by HIPAA. Some examples of business associates are claims processors, there's data analysis, utilization review, quality assurance, patient safety activities, billing, benefit management, practice management, repricing. So those entities that do those activities are your traditional business associates. It can also be a person who provides any of the following services to or for a covered entity or organized healthcare arrangement where the provision of the service involves the disclosure of PHI from the covered entity or the organized healthcare arrangement or from another business associate. So some examples of that could be legal, actuarial, accounting, consulting, data aggregation, management, administrative, accreditation, financial. So those are entities that would be working with a covered entity. Another business associate is a subcontractor that creates, receives, maintains, or transmits PHI on behalf of the business associate. And a person becomes a business associate by definition, not by the act of contracting with a covered entity or otherwise. And as a general rule, a covered entity may disclose PHI to a business associate in accordance with a BAA, business associate agreement. A covered entity is required to have a BAA if a person or an entity is deemed a business associate. I mentioned PHI, and just to let everyone know, I'm not tracking the chat or the Q&A, and I can take questions at the end. So I'll be going through the presentation, and I see that there are questions, and I can we'll have some time at the end and also provide my email. So there is a handout that provides the types of PHI, and it's a list of 18. This is with health information. So a lot of folks think, especially early on when HIPAA was getting implemented, I did benefits consulting for large companies, and they would say, oh, you know, there's a social security number, and so HIPAA, and they'll just sort of bring that up just by having a social security number or knowing a social security number, that somehow it involves HIPAA. But there needs to be, for it to be PHI specifically, there needs to be some sort of health information related to it. So for example, if you're being treated at UCSF, and on their envelope, they note that the return address mentions HIV, and that letter is sent out by UCSF, that could be a disclosure of PHI, because there's potentially the health information, the diagnosis is on the outside of the envelope, and it has the name and address of someone. But if there's nothing to that effect on the envelope, then there wouldn't be a concern about disclosing. I do want to, and I'll go into this a little bit further later. Number 18 is any other unique identifying number, code, or characteristic. So that's a catch-all, and it can lead to someone's PHI being disclosed. If someone says that they're so-and-so was my patient, and they have a dog named Fluffy, and it's a pit bull, and they go into details, then they could potentially be disclosing PHI. So just a quick summary of the HIPAA privacy rule. The privacy rule became effective on April 14th, 2001. So it's been 20 years. And the primary purpose is to ensure the privacy of patients is protected while allowing health data to flow freely between authorized individuals for certain healthcare activities. And some of this is going to sound a little redundant, but it's really important that I make it clear that who follows the privacy rule are covered entities. So those are health plans, healthcare clearinghouses, healthcare providers. And what are the covered entities required to do? They must protect the privacy and security of the PHI. They must adhere to the minimum necessary standard for use and disclosure of protected health information. They have to notify patients of their rights for access, use, and disclosure of their health information. And they have to report privacy violations to affected patients and the Department of Health and Human Services. So there are administrative requirements that covered entities must follow. They have to designate a privacy officer. They have to designate a contact person or office to receive complaints and provide further information. They have to provide privacy training to all workforce members. They must develop and apply a sanction policy for workforce members who fail to comply, implement policies and procedures designed to comply with standards, implement administrative, technical, and physical safeguards to protect privacy of PHI, mitigate any harmful effect of a violation known to the covered entity to the extent practicable, provide an internal complaint process for individuals, refrain from intimidating and retaliatory acts, and not require individuals to waive their rights. As I mentioned again, what covered entities are, but there can be hybrid entities that are governed by HIPAA. So I worked for the Department of Health and Human Services, where I represented CMS, the Centers for Medicare and Medicaid Services, and I also represented the Indian Health Service, which is both a provider, and they, but we also, we were involved in administrative legal actions and litigation. So, we would need to get access to protected health information, but we were protecting our patients under the Indian Health Service, where we would serve patients in that capacity. And then a business associate, a contract is usually required for them to be regulated by HIPAA. Business associates may use or disclose PHI only if such use or disclosure is in accordance with the HIPAA privacy rules required terms for the business associate contracts. So some examples of scenarios that may trigger business associate obligations. A physician contacts you to defend her in a medical malpractice action where you will need to review her records. A hospital contacts you to provide advice regarding an unpaid patient bill. A nursing home asks to interview residents regarding an adverse incident, or a billing company calls with a regulatory question and asks to review claims. And some additional examples for business associates: a pharmacy asks you to review its policies and procedures. Employer asks you to help determine whether an employee is entitled to family medical leave. A life insurance company or workers' comp plan asks to defend it in a lawsuit brought by an insured. Most likely our clients would be on the other side of that. So it's important to note that a business associate can violate HIPAA. But also an individual insured in an automobile accident asks you to file a lawsuit, or an estate planning attorney, works with a client where you draft a healthcare power of attorney. Sorry, I meant that's where they don't trigger business associate obligations. I apologize. So these are examples of where they would not be business associate. So if you're representing an individual in these lawsuits, you would not be a business associate. So sorry about that confusion. So some key points about uses and disclosures. There's no use or disclosure of PHI unless it's permitted or required by the privacy rule. And some required disclosures are to the individual who is the subject of the PHI. So if an individual asks to have the PHI disclosed, that's required. And then it's also required if the Secretary of HHS requires it in order to determine whether a covered entity or a business associate complied. But all other uses and disclosures are permissive, so they're not required. And covered entities may provide greater protection. So for example, they can require, before they disclose information, they could have on their authorization form to disclose PHI, they could include HIV status or treatment, and they can offer those greater protections even though HIPAA doesn't specifically have those greater protections. Most mental health information is protected to the same degree and manner as other PHI, but there is an exception for psychotherapy notes that are maintained separately from the rest of the patient's medical record. So the relevant permissible disclosures of PHI under the privacy rule may include, with authorization of patient or a personal representative, and then without authorization, subject to some conditions, the permissible disclosures are for treatment to those involved in the care or payment for care, to parents, family, or others involved in care, with the opportunity to agree for the patient, the individual, to agree or object in order to avert a serious or imminent threat to health or safety, to law enforcement, or as required by other law. And then more specifically, there are specific public priorities that may allow use or disclosure. And I'll go into this in a little bit more detail. We call this TPO, for treatment, payment, or healthcare operations. The PHI can be disclosed in that. And treatment also includes the coordination or management of healthcare by a healthcare provider with a third party, which could include others responsible for following the care of the individual after discharge. As to disclosure to individuals, besides making the required disclosures, covered entities may also disclose PHI to their patients or enrollees. So health plans may contact their enrollees, and providers may contact or speak with their patients. Covered entities must treat a personal representative, that is a person who has authority to make a decision related to a person's healthcare, as an individual. So if someone is designated by the patient as a personal representative, the covered entity needs to treat that person as the individual. PHI may be disclosed to parents or other persons who are involved in care as personal representatives of the patient. If the patient doesn't object, relevant PHI may also be disclosed to family members or other persons that are involved who may not be personal representatives. It's up to the patient. There can be incidental use and disclosures, and the privacy rule permits uses and disclosures that are incidental but would otherwise be permitted, as long as the minimum necessary is provided. So an example is talking to a patient in a semi-private room, talking to other providers if passersby are present, waiting room sign-in sheets, patient charts at a bedside. If you're sharing rooms, sometimes it's unavoidable. And it basically, it allows for common practices to be reasonably performed. You may, if you go to a doctor's office and you have to sign in, so other people will see the sign-in sheet, and that's incidental, and it's, otherwise healthcare providers may not be able to continue to conduct their practice. So, we do have to use common sense and what's reasonable. To disclose PHI to people involved in care or payment for care, that can also be disclosed, but the patient has to have the opportunity to agree or object. So friends may pick up prescriptions, hospitals may notify family members of a patient's condition, and covered entities may notify disaster relief agencies about a patient. Again, as long as the patient is given the opportunity to agree or object, or if the patient is giving the friend the opportunity to, they say that it's okay for them to pick up their prescription, then that's fine. So I've alluded to the minimum necessary standard. This is what it means. Covered entities must make reasonable efforts to use, disclose, or request the minimum necessary PHI based on purpose. Exceptions to the minimum necessary standard do exist, such as disclosure PHI for the purpose of treatment. Sometimes there may be more information that isn't really needed, but if it's all on one chart and there's a lot listed there, and it'd be onerous to not include what's already there. But covered entities must develop criteria to limit disclosures of and requests for PHI to the minimum necessary. PHI may be disclosed with written signed authorization. The patient or patient's personal representative authorization must meet the requirements of the privacy rule. And personal representatives include, for adults or emancipated minors, persons with legal authority to make healthcare decisions on behalf of the patient. So if there's a power of attorney that's already identified, that would be an example for an adult. But if we're talking about minors, unemancipated minors, and the definition of a minor varies by state, but in general, the parents and guardians of minors are already automatically personal representatives. There are also particular rules depending on the age of the minor, where there's more information that could be restricted, but under HIPAA, it's based on state law. Basically, if there are more restrictions, where there may be information for a minor over the age of 12, there are certain things that they can consent to based on state law. So another place that PHI can be used or disclosed are with court orders and subpoenas. But a HIPAA covered entity may share PHI if it has a court order, and this includes the order of an administrative tribunal. But the provider or plan may only disclose the information specifically described in the order. So this, I worked with the Indian Health Service, and so we may have gotten subpoenas from a tribal court, and that's legitimate, of course, and but we want to keep it to the minimum necessary, so they need to specifically note in the court order what is being requested. And a subpoena issued by someone other than a judge, such as a court clerk or an attorney in a case, is different from a court order. A HIPAA covered provider or plan may disclose information to a party issuing a subpoena only if the notification requirements of this privacy rule are met. And if this is something that you think you're going to need to do, look at 45 CFR section 164.512E. And then before responding to a subpoena, the provider or plan should receive evidence that there were reasonable efforts to notify the person who's the subject of the information about the request, so the person has a chance to object to the disclosure or seek a qualified protective order for the information from the court. This really should be a last ditch effort that you would need. that for whatever reason, if you need someone's PHI and need to get a subpoena, there are strict requirements, always best just to get it directly from the patient. If it's your client, you just get their authorization. You should not need a court order or subpoena. That would be in a different scenario. But if it's a witness or third party, and you're requesting that, again, if whatever you can do to get it directly from the person whose PHI it is, that's the route I would go. So when is a HIPAA authorization to release medical information form required? It's required to be obtained from a patient before their PHI is disclosed for any purpose other than those detailed in 45 CFR section 164.506, and they're specifically covered in section 164.508. And in summary, so before it's disclosed to a third party for reasons other than provision of treatment, payment, or other standard healthcare operations, for example, disclosing information to an insurance underwriter, prior to PHI being used for marketing or fundraising purposes, prior to PHI being provided to a research organization, prior to psychotherapy notes being disclosed, prior to the sale of PHI or sharing that involves remuneration. And what should be on the authorization form? It must, at the very least, contain the following information: a description of the information that will be used or disclosed, the purpose for which the information will be disclosed, the name of the person or entity to whom the information will be disclosed, an expiration date or expiration event when consent to use or disclose the information is withdrawn. For example, an expiration event may be when a research study is completed, a signature and date the authorization is signed by an individual or an individual's representative. If a representative is signing the form, the relationship with the patient must be detailed along with a description of the representative's authority to act on behalf of the patient. So if there's a power of attorney, or if it's a deceased person, then needs to be an explanation for how they have the authority. The form must also include statements that advise the individual of their right to revoke the authorization, any exceptions to the individual's right to revoke, details of how the authorization can be revoked, and to the extent that the individual's right to revoke is included in the notice, it's required by the notice of privacy practices, which is in CFR section 45 CFR section 164.520. I'll go a little bit into the notice of privacy practices in a bit. Also, that the covered entity may not condition the treatment, payment, enrollment, or eligibility for benefits on whether the individual signs the authorization, that there is potential for information disclosed under the terms of the authorization to be redisclosed by the recipient, and then it would no longer be protected. And that's in 45 CFR 164, subpart E. The release must be written in plain language, and a copy of the signed form should be provided to the patient. So not a bunch of legalese, make sure that the patient understands what they're signing. This is an example of a form. This is in the materials that were sent out. This is from the Indian Health Service, and my recommendation is, I've seen a lot of attorneys who create their own HIPAA authorization forms, and they just have the client sign those, and then they send it off, and then they don't know why they're not hearing back from the healthcare provider. Because they have really strict requirements and they don't want to violate HIPAA. Most healthcare providers have their own forms, and I highly recommend that you find their form and have that filled out, because all the requirements will already be in there. And if it's filled out properly, then that will expedite the process. And they know that it's a proper form. It doesn't really have to be reviewed. So in this example, it's the Indian Health Service form. So a lot of times what I would do is we would get a subpoena and I would say, why not just have your client fill out this form and submit that, and then the records will get released. So you can see what they include. If you are going to do your own form, perhaps it's a smaller healthcare provider, maybe they don't have their own, but the major healthcare providers and covered entities should have their own forms, and you should use those. And then I noted here that at least in the case of the Indian Health Service, and to comply with most laws, they do have highlighted the sensitive information, which includes alcohol, drug abuse treatment, sexually transmitted diseases, HIV/AIDS related treatment, mental health, and then there's a special box for the psychotherapy notes. So HIPAA, which was extended by the HITECH Act, gives patients specific rights. They need to get a notice of privacy practices. They have the right to access, inspect, and copy their own PHI in both paper or electronic formats. They can request amendments to information. They can request restriction of PHI uses and disclosures. They have the right to restrict disclosure to health plans for services self-paid in full. We call that the self-pay restriction. And some examples of that, potentially if someone is getting treated for HIV, for example, and they don't want their health plan to know, they can ask that their treatment be carved out and they can self-pay, and so that that information wouldn't go to their health insurer. I worked with pediatrician offices and OBGYN offices, and sometimes folks would ask for the self-pay restriction because sometimes they didn't want their partners or their families or parents to know about certain treatments, and so they would ask for the self-pay restriction so that it wouldn't come on the EOB, on the explanation of benefits. They may request alternative forms of communications, such as, please mail this to a PO box, not to my home address. Don't leave any messages on my answering machine. That's something that they should always opt into anyway. And then they also have a right to an accounting of disclosures of PHI, and they have a right to complain to the covered entity and to the Secretary of HHS. And they should refer to the Notice of Privacy Practices to determine where to direct these requests. In the materials that I sent, I included examples of all of those types of requests and access. And again, I use the Indian Health Service forms are public, and so we can use those as an example of the forms that are used for patients to go over. And I also included the sample Health and Human Services Notice of Privacy Practices. And this, I'm actually just a little screenshot of UCSF has their Notice of Privacy Practices public, and this is a requirement of the privacy rule. They must give each patient a notice of the privacy practice that describes how it may use and disclose PHI, advises the patient of their privacy rights. They must obtain the patient's signature acknowledging receipt of the notice, except in emergency situations. If If a signature is not obtained, the covered entity must document the reason why, and they have to make a good faith effort. So if there's an emergency, and someone is rushed to the hospital, they're unconscious, and the covered entity, the hospital, needs to document why they will likely not have been able to get the notice of privacy practices acknowledged and signed. The notice of privacy practice will lay out what a client needs to do to enforce their rights or make complaints. And in most cases, the covered entity must post and provide a copy to the individual on first contact with providers and upon enrollment with the health plan and upon request. It doesn't need to be re-signed for ongoing treatment unless changes were made. If I go to my doctor, if I go once a year for preventive care and they haven't changed their notice of privacy practice, I don't need to re-sign it. But I can ask to see it. Sometimes people can they think, oh, it needs to be signed every time, but it's not necessary if it's just for ongoing treatment. But they do need access to it. Now a lot of things are online, but if you're showing up for the first time to get treatment for something, then they should hand you the notice of privacy practices for you to sign, or perhaps they'll email it to you and you do an e-signature, but you need to acknowledge that you've received it. So just to go in a little bit more detail on these requirements, an individual has a right to inspect and obtain a copy of their PHI in a designated record set for as long as that designated record set is maintained. And reasonable fees are allowed for copying and postage only. No retrieval fees are allowed. So if you're requesting the PHI, the healthcare provider may say, well, if you want hard copies of this, it's going to cost 5 cents per page, and it's going to cost us to mail it. In a legal context, if you're filing a lawsuit on behalf of a client and you're requesting this information and you're asking for it in hard copy, they are allowed to charge. Covered entity and provider must permit the individual to request and accommodate reasonable requests to receive communications by alternative means and alternative locations. And it applies to health plans if the individual clearly states that the disclosure could endanger the individual. The information that must be protected is PHI that's collected or created as a consequence of providing healthcare. PHI is information related to a patient's past, present, or future physical and/or mental health or condition. It includes at least one of the 18 personal identifiers that are in one of the handouts, and I had listed earlier. It's any format, written, spoken, or electronic. And it includes health information about individuals who have been deceased less than 50 years. So yes, people are protected under HIPAA for 50 years after death. So the notice of privacy practices allows a covered entity to use and disclose PHI for treatment, payment, and operations. So a treatment example is a patient's referring doctor requests a copy of the patient's recent exam at UCSF. So they're using, it's a physician that doesn't work for UCSF, but the patient was referred. So that's an example of treatment. And so PHI can be disclosed then. Patient's insurance company requests a copy of the patient's medical record for a specific service date to validate medical necessity. And then operations is another scenario where PHI can be disclosed. So for example, Quality Improvement Office requests a copy of an operative report. Covered entity must have a business associate agreement with vendors who will access or use PHI when providing a service on behalf of the covered entity. And if there's a valid business associate agreement, the same applies, and the information can be disclosed if it involves treatment, payment, or operations. So just a little bit more detail. I mentioned some of these other uses and disclosures earlier, but the PHI may be provided in these examples. Directory information, so knowing that someone is at a certain hospital, that may, that may be included. If it's required by law, there are public health activities where the PHI may be disclosed. So specifically now with COVID, in order to stop the spread of COVID, there may be instances where PHI may be needed to be disclosed in order to prevent further spread of an infectious disease. To report abuse or neglect, other health oversight activities related to judicial administrative proceedings, but it may, again, there may be court order subpoena required there. It can be disclosed if there are law enforcement purposes. It can be disclosed to coroners, medical examiners, and funeral directors for donation purposes and transplant procedures. If there's a serious threat to health and safety, for essential government functions, for workers' compensation, and limited data sets can be used for research purposes. So unless required or permitted by law, the covered entity must obtain written authorization from the patient to access, use, or disclose their information for purposes that are other than the treatment, payment, and operations. There is an exception in the final omnibus rule that provided greater flexibility to release immunization records to schools where the state law requires them to have proof of immunization. So while you still need to obtain parental agreement to disclose the records, this agreement can be verbal or written. The verbal agreement must be documented in the patient's record. PHI can be used in human subjects research, but it's after an institutional review board or IRB has approved the research, and both informed consent and a HIPAA authorization have been signed by the subject, or the IRB has approved a waiver of HIPAA authorization. If PHI is obtained for research purposes with only an informed consent, but without a HIPAA authorization, it is considered an unauthorized disclosure under HIPAA. So if you're part of a research study, or you have a client who's part of a research study, they need to sign both informed consent and a HIPAA authorization if they're going to be using their PHI in the study. So I'm going to go through some guidance for people who may be handling PHI. And specifically the minimum necessary standard. HIPAA requires users to access the minimum amount of information necessary to perform their duties. For example, billing clerk may need to know what laboratory test was done and on what date, but not the result. For patient care and treatment, HIPAA does not impose restrictions on use and disclosure of PHI by healthcare providers. So there are exceptions, though, with the minimum necessary standard. Psychotherapy information, HIV test results, and substance abuse information. I'm getting some background noise. Give me just one. Sorry about that. So with psychotherapy information, HIV test results, and substance abuse information, there are exceptions where you will want to specifically ask for that additional information and give potentially there may need to be a particular reason why they need that information. Verbal exchanges are included as PHI, and patients may feel that verbal conversations as part of normal clinical operations are a violation of their privacy. So that's something to be aware of. There may be incidental disclosures. Don't leave PHI on voicemail. And again, this, depending on your background or where you're working, a lot of this is, if you were to be handling PHI, this is hard copy PHI. Know where you left your paperwork, and this is just good practice anyway for confidentiality reasons. Double check when mailing or handing documents to patients or family members, or scanning or faxing documents. Slow down and verify that each document belongs to the correct patient. Best practice is to verify and highlight multiple patient identifiers, for example, full name, date of birth on each page. Staple and highlight verified pages of the document together. Check printers, faxes, and copier machines when you're done using them. Don't leave paper PHI laying around on your desk. Lock it up at the end of the day. Be alert to how many copies you're making. For example, if you accidentally print 2 copies, be sure to retrieve the extra copy from the machine. So if you're in an office, or if you're around PHI or confidential information and you see someone left something on the copy machine that looks like it has PHI, I don't recommend leaving it there for anybody. I would shred it. And this is something that happened fairly often when I worked for healthcare providers and hospitals, that people would accidentally hand the wrong information to the wrong patient, or someone's information to the patient that they shouldn't have gotten it. And so you want to make sure that that's not happening. So dispose of paper and other records with PHI in secure shred bins. If you work with PHI, don't use regular trash or recycling bins to dispose PHI. Shred bins only work when papers are put inside the bins. And so find a secure shred bin. If you're in a place where you're handling PHI, I think most of you, if lawyers in these in our practice areas, we wouldn't necessarily be in this scenario. But if you're thinking it from the healthcare provider perspective, or if you represent someone who's an individual who works for a covered entity, it's important that they know that they should be doing these things, and they should be putting everything into secure shred bins. So the best practice for handling hard copy PHI is not to take it offsite from the workplace, from the covered entity. If it must be taken offsite, transported, the information should be de-identified. We always say treat PHI like it's an infant. Must be kept on your person at all times. I like to say don't put it in the trunk of your car. You wouldn't put a person in the trunk of your car, I hope. Or even we'll get a little bit into ePHI, into electronic PHI, but same thing with a laptop. If you have sensitive information on a laptop, treat it like it's an infant that you would take with you, and not leave it in the trunk of your car, because those get stolen even from the trunk. And guidance for handling electronic PHI. If you use your personal electronic device for covered entity business, it must be encrypted because you can be held individually liable for breaches. And encryption is the only federally recognized method for securing ePHI. Got a little trigger finger with my mouse. Just a quick quiz that I'll give the answer to. So I do not work with patients or have access to medical records. However, I see patients pass by my desk in the clinic. Can I talk about the patients with my coworkers, family, and friends, even if it has nothing to do with my job? And so we've got 3 choices there. In the interest of time, I'm going to skip to the punchline. The correct answer is A, information can only be used as needed for your job. So handling PHI and the use of social media, and these are good practices generally for privacy and confidentiality. Do not share on social media any patient information acquired through work, even if the information is public. Information obtained from a patient-provider relationship is confidential. Posting patient information without authorization is a violation of the patient's right to privacy and confidentiality. And even if someone thinks it's been de-identified, it still might be identifiable to others. I mentioned earlier, there was the catch-all, any other unique identifying number, code, or characteristic, a photo of a wound, or description of a patient's condition. Here's an example where a nurse is very upset because a patient has just coded and was not able to be resuscitated. The nurse wants to share the experience and thoughts and feelings with family and friends on Facebook. Can the nurse share this? And I will go to the answer. That the correct answer is C, because Facebook is considered public domain and anything you post there is considered public information. So don't post if you're handling PHI and you are posting something that could be PHI. A Facebook profile may identify someone's place of work and occupation. When linked with the posting and with any other publicly available information, the additional details may identify the patient. Information obtained from a patient-provider relationship is confidential. Covered entity staff members have a right to engage with a personal representative as needed, but don't share PHI with an external representative. So the staff member shouldn't be sharing PHI with you if you're the patient's attorney. The union representative shouldn't be getting that PHI information. If someone's involved in a labor-related incident and PHI is necessary to be shared, then the employee, the staff member of the covered entity should contact their labor and employee relations. So just thinking of it in the context of, if you have an employment law client and perhaps something came up and they needed to share PHI, or there's some sort of issue, labor issue, then they need to work through their labor and employee relations. So here's another scenario for someone who would be handling PHI. My coworker's spouse notified me that my coworker was recently admitted to the emergency department and won't be coming into work tomorrow. My coworker and I have a great relationship and I'd like to know how she's doing. May I access the records to check on her condition? So just jumping to the answer, the correct answer is C here, because it's not part of the job it's not part of their job. They're just sort of curious, nosy, maybe. Your access to your coworker's record would be for personal reasons. Therefore, accessing the record will be a violation of the coworker's privacy. And furthermore, your access to the record will automatically be recorded and tracked if they're working for most everything is on electronic health records now in every entity. So that's all being tracked and and that has to be tracked in order to comply with the accounting of disclosures that patients have a right to. So there could be serious consequences to someone's employment if they're poking around to see, whether their coworker's okay. And so if someone works for either a covered entity or a business associate of a covered entity, this would be a HIPAA breach if they were looking at a coworker's information, PHI. I mentioned laptop. Again, if you have someone who's handling PHI, an example, they have a personal laptop at home, which I sometimes use to check my work email on the weekends. However, I never save my files containing PHI onto my laptop. Does it still need to be encrypted? Just go to the answer there was B, and your laptop must be encrypted. If you work for a covered entity, if someone's working for a covered entity, they need to have a laptop that is encrypted because they're accessing their work email. There could still be work data that's getting pulled. And if the device is lost or stolen, the information in it, if it's encrypted, then it's inaccessible and it can be locked down. So I just have some examples here. This is just on security, and I think these are good. Not just for HIPAA. I wanted to highlight these things because I think these are good practices that you always ensure that your computer is physically secured and locked down, and that you consider using a privacy screen if you're in an environment where people are walking back and forth. If you have PHI, and you can always, at least on PCs, you can do Control-Alt-Delete to lock down your computer, and then always make sure that your security patches and updates are going through. Emails containing PHI should be sent using a secure email system. So usually, for example, UCSF uses trigger words. So if UCSF is sending you PHI, they should be sending you'll get an email that will have those trigger words, and then you'll probably have to, you'll have to, if you're external to UCSF, you would have to log in separately, and that would keep it secure. Never put PHI in a subject line or an invitation. I think this is just a good practice anyway. So in our at ALRP, I even recommend that you just use initials and not put client names in a subject line or an invitation, because then it's all there and you can see where they are, and that they're working with us, with AIDS Legal Referral Panel. The best practice is to use secure email whenever transmitting PHI, regardless of whether it's internal or external. So if you think you're working with PHI, determine a way to transmit it securely. So practice safe emailing. Don't open, forward, or reply to suspicious emails. Don't provide usernames and passwords. Clients shouldn't be saying, oh, in order to get into my EHR, you can, a lot of places use MyChart now for their electronic health record. And so, a patient can look up they get a login and they can look up their own information, but they shouldn't be giving you their passwords or anything like that. So we should go through a proper process to get that information. So here's just a scenario for security in general that I think is good practice. Again, it's not necessarily just related to PHI, but just something to be aware of. Our little scenario, I received an email from Bill Hirsch, the executive director of ALRP, requesting my user ID and password. I should A, provide my user ID and password, B, provide my user ID but not my password, provide my password but not my user ID, or D, never share my user ID and password. So never share your user ID and password with anyone. Really is not a good idea, but certainly not in emails. We have had some phishing attempts at our organization where it looks like it's an email from Bill Hirsch, for example, but you can hover over it and you can see that it's not actually that email. Don't forward it. If you get something that looks suspicious, just delete it. Privacy breaches should be reported immediately. Immediately report lost or stolen devices, and immediately report any unusual or suspected information security incidents. If you know of UCSF, for example, you saw that there was some PHI floating out in someone's garbage can, contact UCSF and tell them, report that. Federal and state law requires that unauthorized access, use, or disclosure of patient medical information be reported within a very short time frame to the California Department of Public Health and HHS, and to the affected patients or their legal representative. Any person or organization can file complaints with OCR, and it's generally within 180 days. OCR may investigate complaints and may conduct compliance reviews. Covered entity must provide OCR with access to records. They have subpoena authority, and OCR shall attempt to resolve non-compliance by informal means. So we do get questions periodically from clients about making complaints. I mentioned earlier the notice of privacy practices should have, if there's a particular, you know that it was a particular covered entity that may have disclosed improperly, the client or the patient should look to see where the complaint should be lodged. And a lot of times there's still by mail, but there may be portals, there may be a hotline. So look at that notice. That's why the notice of privacy practices is important for letting the entity know. But for complaints to OCR, anyone can file a health information privacy or security complaint. So it doesn't have to be the patient, but they do need to know certain information. It can be filed in writing by mail, fax, email, or by the OCR complaint portal, which I've put here. They need to know the covered entity or business associate involved, and they need to describe the acts or omissions that they believe violated the requirements of the privacy, security, or breach notification rules. And it has to be filed within 180 days. I mentioned that. They might extend it, and so that's 6 months. That's a short statute of limitations. It may be extended with good cause. So it's basically, I mean, if they didn't have any idea that it happened and then they found out after the 6 months, then they can still submit it and see. And then I included the link to the complaint process that goes into more detail. This is what the complaint portal looks like. So you can see, so this would, on question 1, we're talking about violation of privacy or security of health information under HIPAA. And then they ask that, whether it was in the last 6 months or if it was over 6 months ago, and then it goes into more detail from there. Covered entities must notify each affected individual of a breach of unsecured PHI. A business associate, if they find out that there's a breach, they have to notify the covered entity of the breach. If more than 500 people are affected, the covered entity or business associate, usually the covered entity, has to give notice to the media, and the notifications have to be provided without unreasonable delay, but not later than within 60 days of discovery of the breach. And then I included a link where you can see where the breach and notices happen. This is an example of where you can look this up, the breach portal. You can see some of the examples of breaches that were included there. Every complaint received by OCR is reviewed and the allegations are analyzed. An investigation is launched when it's warranted by the facts and circumstances presented by the complaint. So the portal is good because it goes through, exactly what is needed for them to for HHS to investigate. OCR investigations have resulted in changes in privacy practices and other corrective actions in over 29,081 cases since April 2003, when compliance was required. In 176,541 cases, OCR determined that complaints did not present an eligible case. So there's not a huge yield there, but if there's something that happens, it's worth filing the complaint. But again, this is to OCR. This is not a private right of action. So an individual may report, and it doesn't have to have happened to them. They might have more information if it happened to them, but they're not necessarily going to see an immediate impact or know what the outcome is. They're not going to get any damages from it. Basically, if there's something if there is something to follow up in a corrective action, then OCR will follow up with the covered entity or the business associate to make sure that they get into compliance. The compliance issues that are investigated most frequently are impermissible use or disclosure of an individual's identifiable health information, such as viewing your own PHI, that of a coworker, or of a family member, telling PHI from work to someone outside of work. Some more of those are the lack of adequate safeguards to protect identifiable health information, refusal or failure to provide an individual access to their own records, the disclosure of more information than is minimally necessary to satisfy particular request for information, or the failure to have the individual's valid authorization for a disclosure that requires one. Some indications of noncompliance under 45 CFR section 160.312. If investigation or compliance review indicates noncompliance, HHS will attempt to reach resolution by informal means, which includes demonstrated compliance, completed a corrective action plan, or some other agreement that OCR has made with the covered entity. Just we're running low on time, so I'm just going to go through quickly that privacy violations may carry penalties under HIPAA high-tech, as well as state privacy laws and a covered entity's own policies. I'm just covering HIPAA in this presentation. So the HIPAA civil penalties are anywhere from $100 to $1.5 million per violation. And that could be on the covered entity itself. It could be on an individual. The criminal penalties include fines of $50,000 to $250,000, or imprisonment, which of course could be an individual, up to 10 years. And then there could be additional, if the covered entity has workforce policies, so it could jeopardize someone's job if they're snooping around in someone's record, in addition to the federal and state laws that they could be violating, and they could be subject to fines and penalties. And remember that the privacy applies to all verbal, written, and electronic confidential information. So if someone is chatting and it's overheard, and it can be harder to investigate those complaints, but there could be a violation if someone is talking about PHI. And I didn't mention, be careful with texting. I've mentioned don't leave PHI in voicemail, don't text PHI, and generally try to avoid if there's any sensitive information. I don't recommend texting. That's not going to be encrypted. There are some rare circumstances where it is, but if someone is, someone's taking a picture of a wound, for example, and then it gets texted, it's really not a good idea to do that. And as you can see, the enforcement penalties have gone up over the years, but then they've tapered off the last couple of years. So here's just an example of a penalty that that HHS that actually was a settlement. Sorry, there was a settlement that was reached between the St. Luke's Roosevelt Hospital Center, and it was related to HIV services. So this is something that, but again, it's a settlement with OCR and did not involve the individuals. And here's an example of HIV status litigation, where if there was a complaint that was lodged through OCR, then that would be helpful in this type of case, but there's no private right of action. But here's an example where a healthcare provider retained an attorney to collect patient debt, and the public court filings gave a bunch of PHI, and the review board concluded the healthcare provider violated the standard of care for patient privacy. And sure, there's HIPAA violations, and so ultimately the jury awarded damages to a plaintiff in that case. So lawyers are sometimes business associates. I think in our practices, it's less of an issue. There can be even $1 million penalties for covered entities, and criminal penalties. There are state attorneys general who can bring civil actions, but as I mentioned a few times, there's no private right of action, but there can be shared penalties that entities can, or the lawyers could, if they're a business associate or if they're somehow involved in a violation, they might have to pay penalties. So here are some additional resources that I've included here that are in your materials, the OCR website, and some more training if you want to get into more of it. And again, it's HIPAA, H-I-P-A-A. And if you call it HIPAA, one more with 2 P's, this HIPAA will eat you. So I'm going to stop there.
Great, thanks, Phyra. So yeah, thank you, Phyra. You did a great job. I do want to just say one more time, I encourage everyone to complete the brief evaluation at the end of the training. It will appear in your browser when you exit Zoom, and I'll also send it as a link and a follow-up email tomorrow. Evaluations are required for those of you seeking CLE credit. I will email you a certificate for completion once I've received an evaluation from you. So Phyra, there actually are a few questions. Do you want to answer them or?
Sure. And I think if you want maybe to stop the video and I can answer them, because
Great.
you can have that for the online on demand.